Go ahead, Mr. Albee.
Dr. Wong, in the Stallings case, you submitted a report that said you had confirmed mass spec on a sample, and in fact you had not confirmed with mass spec that sample, true?
No, sir. The sample did confirm. It was injected twice. The second time, more sample was injected, and that's when the positive came out. There
was a sample that you indicated on your report confirmed mass spec when in fact you had not?
Well, I'm confused, sir. I don't know. I know there was just what I told you. I said there was one that was injected. It wasn't a lot of sample that was injected, came out negative, then it was re-injected and came up positive. That's what I'm aware of.
I'll show you page 63 from your deposition of December 9th, 1991. But your attention to line 8 on page 63. And you were asked about an amended report that you prepared, correct?
Yes.
And the amended report was prepared in August of 1991.
You don't object to this. This is impeachment by extrinsic evidence.
Well, it's not really impeachment. It's an investigatory interrogation outside the presence of the jury.
Well, then will the witness be permitted to read it before he starts asking questions about it?
I gave it to him for the purpose of reading it. I think that's entirely fair, and if the witness needs more time, he can have it.
All right.
Yes.
And you filed an amended report on what date?
This looks like it was dated August 23rd, 1991.
And that was long after the criminal trial in the Stallings case, correct?
Yes, sir.
So at the time of the Stallings trial, you had not corrected the report, right?
That is correct.
And in that report, you mistakenly put nanograms instead of micrograms, true?
Objection, this is irrelevant.
Just stated.
Well, Judge, I'm making an offer of proof here, and it's one question.
Well, all right, go ahead, but I'm going to tell you now that this is not coming out in front of the jury.
That's fine, but
okay,
that's what an offer of proof is about.
Go ahead.
The units were wrong on the report, yes. It should have been micrograms, and it was listed as nanograms.
And then there was a sample of ethylene glycol that you wrote. You signed a report that said confirmed mass spec when you had not confirmed that sample with a mass spec, true?
I don't recall that, sir. I told you what I recalled.
Are you telling me that that transcript does not refresh your recollection?
That's what I'm telling you, sir. I went through the entire transcript, and there's a lot of things going on in here that I don't know today what's actually in there or what they're referring to.
Well, did you give the following answer at line 11, page 63, regarding the report that you amended after the criminal trial on August 23rd, 1991? Answer. It was amended for two reasons. One is that the unit shows 857 nanograms per mil on the original report, which is Exhibit 221. That's dated September 19th of 89 at 11:15. The second reason is that on the original report, it showed that sample 3856 was confirmed by GC mass spec, and in point of fact, it wasn't. It was sample 3863, which was the next sample for Ryan Stallings. The report was amended to show the unit change from 857 nanograms per mil to 857 micrograms per mil. Did you give that answer at that time?
I believe so, yes, sir.
Was that true?
I believe so, yes, sir.
And what you had done is you'd submitted a report at that criminal trial that said you confirmed mass spec on a sample that had not been confirmed. True?
On that sample, true. On the next sample, which was Ryan Stallings, it was confirmed. It was missed, I guess it was put on a different report.
Now, you also performed some testing on a sample of Ryan Stallings' blood and came up with a negative result. True?
On which sample are you referring? In which testing?
Did you perform testing on Ryan Stallings' blood when you received a negative result for ethylene glycol?
I believe that was the post-mortem. And it would have been negative.
Well, you did, all your testing was post-mortem.
No, I believe we did some ante-mortem.
Well, you testified in the Stallings trial that your post-mortem tests showed ethylene glycol, right?
I don't recall that.
Are you telling me that samples 3863, for example, was not post-mortem?
I don't know. I don't.
I have to tell you, Mr. Alden, that it certainly, you can't always tell what the destination is by what the look of the road is, but it sure looks to me like you're attacking the science again, as opposed to whether the doctor was truthful or lacking in truth, which are the things you're going to be allowed to examine him on, and bias. Those are the things. I'm not going to go into the science of this.
Well, Judge, beginning at page 124 of his December 9th, 1991 deposition,
Are you going to examine him about failure to exercise ordinary care? You're not going to be allowed to do it.
Judge, what I'm doing here is he had a negative sample and he didn't turn it over. He had a negative result and he didn't turn it over to the prosecutor.
Are you going to suggest that he willfully... Here's what the statute says. Let's read it again. I can't locate it right now, but it's probative of truthfulness or untruthfulness. They may, however, subject to, etc., if probative of truthfulness or untruthfulness and not remote in time, be inquired into on cross-examination of the witness. Untruthfulness or untruthfulness. That's the limit of what you can examine him about. And I'm giving you the benefit by letting you examine him about something 20 years ago. And you can examine him about bias, about the need to protect his reputation or whatever, and that's it. And I don't want to get down a road taking up a lot of time about whether or not he conformed to the standard of ordinary care of a toxicologist under the same or similar circumstances. Whether or not that involves an omission in a report or anything else.
Well, Judge, I believe that it does go to the witness's honesty if there's a negative test for his sample that he's testing, and he doesn't turn that over to the prosecutor or alert him to it. I think that does, number one, go to honesty. Second, and that is the purpose that I'm offering.
Make an offer of proof as to how you intend to prove by your cross-examination, because you're not allowed to offer extrinsic evidence, and I'll even give you the benefit of the doubt on that and say if you have some very obvious proof that he's being dishonest, I'll entertain that. But you show me how you are in good faith going to suggest that he was untruthful on a prior occasion, and untruthful meaning either deceitful or so reckless in respect to the presentation of the evidence that it was amounted to an untruthfulness.
Well, Judge, I'd refresh his recollection with this transcript that shows he did not turn over a negative sample, a negative test on a sample. That it showed up negative for ethylene glycol, and he did not produce that information to the prosecutor, and he did not preserve it, and therefore was not available, at least at the time of this deposition. I believe from that information alone, I certainly can invite the jury to draw the inference that his failure to turn over negative samples to the prosecutor is dishonest. Is it the only explanation? Maybe not. But I believe that that's a reasonable inference to be drawn, and I submit Defendant's Exhibit 205 as the information that I would present through questioning to the jury, which explains that
you've got extrinsic evidence.
A negative. I can refresh his record. Judge, these are the kinds of questions that I would ask. I'm making the offer of proof and trying to shorten it by submitting these documents. Go ahead.
I interrupted you. You're right. Did you want to say more? Because I'm going to ask the doctor now for his response.
Okay, I don't think I've asked him the questions, but that's fine. I'm happy to hear what he has to say.
Go ahead. You want to respond to what Mr. Albee is claiming?
I don't know what he is talking about. In reading through the deposition, it referred to a bunch of numbers, a bunch of exhibits, which I couldn't track down, I couldn't trace. The only one that comes to mind is the GCMS was run, and when you inject a little amount, you may not see it. So you have to inject more, and then you see the result. And that's the only thing that I can possibly think of. So it's not a case like it was negative. It was a negative because more had to be injected, and that's when it came up positive.
That's the interpretation you gave in the deposition. I don't have to accept that. There's other reasons why it could be negative, like there's no ethylene glycol in the blood, and it would seem that you turn that over to the prosecution, and it would be determined at the criminal trial in a homicide case as to what was the reason for the negative result.
Well, I'll tell you, and I know nothing about toxicology or most science, but it strikes me that what doctor is saying is that this is a regular routine lab procedure, and if the response isn't indicated on the first injection, that you do it again with a greater quantity of whatever the solvent is, and then you see a result. And the absence of a positive result on the first test would strike me as being just something that is a rather routine examination feature, and calls for the further step of the second injection. And to equate that with a willful withholding of evidence from the district attorney is not supported by a reasonable interpretation. So,
well, I have to say, if I was representing Mrs. Stallings, I'd be all over that if I knew about it at the criminal trial. But the lawyer didn't know about it.
The district attorney. This is not the state here. This is someone who did an examination. If the district attorney were aware of that, I suppose maybe you'd have a justifiable complaint. But this is the scientist doing an examination in the course of ordinary science. So that covers it.
I submit Defendant's Exhibit 205 in support of my offer of proof regarding.
What do you receive for the offer of proof? Now, do you have examination on the subject of?
I've already covered the.
Any other claimed untruthful behavior?
I've already covered the Exhibit 15, and the court has made its determination on that, and then.
Oh, what's 15?
That's the one that was whited out.
Okay. But I want you to be careful on that. I'm kind of amazed that nobody asked the reporter who was here that day for a transcript, because the doctor said some things, and I don't want to go on a fishing expedition here today. The court made its decision based upon what doctor said last time, and now no one has gotten a transcript. But I don't want to get bogged down on that. And now the next thing is what do you propose to ask him on the subject of bias?
Dr. Long, you testified at the homicide trial of Patricia Stallings in 1990 is the trial?
I believe so, yes.
You testified that you had found ethylene glycol in the blood of Ryan Stallings, her son, correct?
Yes, sir.
Following her conviction, the prosecutor reopened the case, correct?
And I want to warn you, you're not going to be asking these questions in front of the jury about what the prosecutor did or didn't do.
Well, for that matter, is he even going to be testifying? Is he going to permit, are you going to permit the counsel to examine this witness about the Patricia Stallings case? My understanding is that the only part of the Patricia Stallings case that was going to be discussed was Exhibit 15, that he was going to be permitted to examine this witness because there was a document that was submitted to the prosecution and 3 numbers were whited out and some numbers were added.
And this is, we talked about this, the Lind case, and I said I thought the Lind case was somewhat confined to its fact because of the fact that I thought the Court of Appeals was suggesting that that the prosecution had misrepresented the expert's, I don't want to say qualifications, his saintliness to the jury, and that it went all the way through the Wisconsin court system, and the conviction was upheld in a rather notorious case, and at the district court level in the federal court, but the Court of Appeals ordered a new trial because federal Court of Appeals because the defendant had been denied the opportunity to examine him regarding bias, and they shot right past the rules of evidence. That's why Mr. Albee's persistent objection about due process comes into play, because they do accept the proposition that sometimes the rules of evidence deny the defendant a fair trial. So we're not going to be able to hold it strictly to the rules of evidence, and I am going to allow him to examine Dr. Long about whether or not he was biased. He is biased in this case, and I understand his assertion to be that he's been under fire because of what happened in the Stallings case, and that he's afraid he'll come under fire in this case because of the statements in the letter that there were large quantities or large concentration of ethylene glycol in the gastric content. So,
have you heard?
Yes.
Your Honor? Okay, first of all, to distinguish the Lind case. In the Lind case, the expert witness, who was a critical expert witness to the state's case, was a psychiatrist who'd examined Lind. And it's true that the prosecution presented this psychiatrist as some really great physician. At the same time that case was pending, this physician was being criminally investigated for having sexual contact with patients. The DA's office that was prosecuting Lind was the same DA's office that would be in a position to evaluate the charges against this psychiatrist and prefer charges against him. And it struck me that the real issue in Lind was that the witness's motivation to please the prosecutor was not just because he was getting paid by the prosecutor, but because this prosecutor could determine whether they're going to charge him with crimes for which this physician could go to prison for a very lengthy time. So there was an altogether different stratosphere of issues in that case than there are in this case. Dr. Long is from St. Louis, Missouri. At the time this case was being prosecuted, was the Kenosha County District Attorney.
But he's not alleging that he's in fear of being criminally prosecuted.
But Judge, if you're going to say, okay, were you subject to criticism because of that? I mean, there was a commentator on the television yesterday that was suggesting that there was some sort of a conspiracy to frame Mr. Jensen that on the part of the prosecutor in this case. So from here on in, now am I going to be answered to that in any court of the land? Oh, somebody said you framed Mark Jensen. You know, it's the fact of the matter is that because the case is notorious, it's going to get publicity. And the people that are connected with the case get publicity. Everybody connected with the O.J. Simpson case. Oh, there's all kinds of publicity because it was the O.J. Simpson case. But how does that affect the science involved? It doesn't. And so now because Dr. Long testified in a case that was a notorious case, and now he's testifying in another case which may become a notorious case, who knows? What's that got to do with the science, Judge? All that has to do with is the number of second guessers and naysayers that you're going to see on television or hear on the radio, picking apart what the prosecutor does, picking apart what the defense attorney is, and picking apart what the expert witnesses did, and picking apart what the judge did.
Mr. Albee?
First of all, I believe that my examination of Dr. Long, which is in the nature of an offer of proof, will be brief if I'm allowed to pursue it and just ask some questions. I understand that the court is not likely to allow me to ask the same questions in front of the jury, but I don't know how else to proceed so that the full picture is presented, and I don't intend to be very long with that examination. It's just a few foundation questions about what happened in the Stallings case, and then we can talk about the legal arguments in light of the facts that are presented instead of what are assumed to be presented.
Well,
Second,
Judge, why don't you go ahead and ask your questions, and then we'll.
if I may, just so I'm clear, so I give everybody a heads up on what the legal arguments are. The rules of evidence clearly permit this kind of examination. It's 90404 sub 2 allows me to produce evidence of bias or motive of a witness. In addition, bias and motive it's established, are not collateral matters. Davis v. Alaska is one of the cases standing for that proposition. Next, I have a constitutional right to confrontation, due process, and to present a defense that I believe also allow me to question this witness regarding these matters. And last, I think all these matters that I've tried to get into go to the qualifications of this witness, which I think is a relevant subject, and under the rules of relevance is also admissible. So, but if I could just ask the questions. Dr. Long, following Mrs. Stallings' conviction, the prosecutor reopened the case, correct?
Yes.
Subsequent to that, the prosecutor dismissed the case, right?
Yes.
And it was the prosecutor's determination that the substance in Ryan Stallings' blood was likely propionic acid rather than ethylene glycol?
Objection. No foundation as to what motivated the prosecutor, and furthermore, there's no foundation that the prosecutor know the difference between propionic acid and antifreeze.
Not offering for its truth, it's for this witness's knowledge.
Well, let me answer, but I agree with your general intention.
Correct?
I don't know.
You didn't hear any news conferences at which that was discussed?
You're asking him to respond to what he heard at a news conference?
It's his bias and motive based on his knowledge.
Go ahead.
20 years ago, I don't recall much of anything from that case. And if it wasn't for you having the transcript, I wouldn't even have looked at it. I haven't looked at the data in 20 years.
This was a highly publicized case in the St. Louis area, correct?
Yes, sir, it was.
There were newspaper and magazine articles about it?
Yes, there were.
There was a TV movie about it, correct?
Yes, there was.
And what was publicized was that there was a laboratory error that caused this woman to be wrongly convicted, right?
I believe that was the conclusion of it, yes.
And you were the lab...
Conclusion of what?
Of all the movies and so forth. That was the conclusion.
Go ahead.
And you were the person who had conducted some of the lab tests, correct?
There were 3 laboratories. There was us, there was the SmithKline lab, and there was the Missouri Highway Patrol lab. All 3 came in with the same results.
And all 3 were criticized for their results during this publicity, right?
To the best of my recollection, I'm not sure if all were. I don't know if the Missouri Highway Patrol was.
Okay, your laboratory was criticized for your results, right?
Yes, sir.
And because this was highly publicized, it reflected adversely on your reputation at the time, right?
Well, in a high-profile case, notorious, I guess you could say it did reflect adversely.
And certainly in the St. Louis area, this case is still well known, right?
No, I don't think so.
There was even a television show about it within the past year, right?
I didn't know that.
And do you acknowledge that you made a mistake in that case?
Yes, sir, I did.
You recognize that it was not ethylene glycol?
I recognize that I can't say it's ethylene glycol. The data doesn't support it. It certainly could be something else. And given all the evidence on the other side, yes, sir, I made a mistake.
At the time of the civil deposition, you were still denying having made a mistake, correct?
That was, what, 91? Yes, sir.
And in this case, you made a mistake regarding the amount of ethylene glycol in Julie Jensen's stomach, correct?
I used the word large, and that was incorrect, and we've gone over that.
And this is another highly publicized case, correct?
It sure is.
And you can understand how making another mistake in a highly publicized case could affect adversely on your reputation?
Well, I don't think the large is going to adversely reflect on my reputation.
Well, you have reason to minimize the extent of your mistake in this case, don't you?
I don't, no, sir. I told you the truth. I told you why I said it was large, and you pointed it out, how much it was, and I said, you're right, I was wrong, I made a mistake.
And you have reason to want to minimize the extent of that mistake, correct?
No, I want to tell you the truth.
That's my offer of proof.
All right, did you want to do anything for clarification? I don't want an extensive examination on this.
I don't see any point for any clarification. And I think that all this stuff about bias is irrelevant. And I don't even see what portion, are you going to allow him to examine this witness on issues of bias? Because he testified in a notorious case 20 years ago, and he's testifying in a notorious case now? Is that?
I don't know about you, but I don't really want to try this case twice.
I don't either.
And, you know, I think that we should be a little bit cautious. We've already got a huge issue because the Supreme Court of the United States has accepted certiorari on the very issue that the Supreme Court of Wisconsin ordered that the forfeiture hearing be conducted. And so there's already an enormous issue about this. It's an 8-week trial, and I think that I would rather err on the side of caution on the issue of whether or not Doctor has a bias. Now, I'm not going to allow an extensive examination. I'm not going to allow anything about the nature of the Stallings case or what the district attorney did or what, by the way, I guess I do want to know, before I finally make a decision on this, I guess I want to understand, you didn't mention anything about a peer review article when you examined the doctor. I'm not going to rely on a TV movie as to whether or not he's been under fire professionally.
He's acknowledged that there was publicity and that the publicity reflected that the laboratories had made a mistake. And, Judge, he said he made a mistake.
A week ago, you told me there were peer review articles critical of Doctor. Then, later on, you said a peer review article, and now I'm hearing about a made-for-TV movie. I'm not going to rely on some common gossip.
Judge, he admitted he made the mistake. I don't need a TV movie.
Mistake. You're right. He has admitted it, which is well.
And mistakes in first-degree intentional homicide cases are bad things.
Find your article.
I believe the jury should understand.
Find your article.
I'm looking for it, Judge. I believe the jury.
Find your article.
It's not interfering.
What did he say?
It's not interfering with my looking for it, is what I was saying. Exhibit 206 is the Journal of Pediatrics.
Is Dr. Long's name in here?
No, I never said it was.
Is it stated that Doctor failed to conform, or the doctor's lab failed, or any of the labs failed to conform to the standard of care that was now then appropriate in this area?
Judge.
Or is it saying for future reference this particular symptoms, these tests should be administered? Which is it?
I don't have the article memorized. I can't say exactly.
You familiar with the article, Doctor?
Is that the Shoemaker article?
Yes.
Yes.
The Shoemaker article isn't even critical of our work. It's critical of the work that was done, if I remember correctly, done at SmithKline. That's the work he duplicated, which is the SmithKline data. This is nothing of the work that I did.
And Your Honor, they weren't even critical of the physicians at SmithKline. Here's what the report says. It says, this report illustrates how propionic acid in the serum of a patient with methylmalonic acidemia can be misidentified as ethylene glycol by procedures using gas chromatography alone rather than gas chromatography mass spectrometry. It was what they were doing. This is what pure reports are supposed to do. They took a terrible and tragic case, and they point. This is where we went wrong. They did not criticize the original persons that did these analyses. Didn't say that they were bad scientists or bad physicians or bad gas chromatograph operators. They simply said, this is where, under these circumstances, a gas chromatograph can cause you to inadvertently misidentify propionic acid as ethylene glycol. That's what this article is about. It is not critical of this physician and of this expert. And to suggest that the doctor should be cross-examined because he tested.
Did you want to respond?
Yes.
Go ahead.
Judge, the point of the article is that there was a mistake made regarding ethylene glycol. This doctor has admitted that mistake. The jury undoubtedly has the impression that mistakes don't get made, that this testing, that this kind of testing, people don't make mistakes, it's sound, and this demonstrates that mistakes get made. And the mistakes aren't always obvious. And this witness made a mistake in another ethylene glycol homicide case, this one, a mistake that I think was substantial.
First of all, he's not acknowledged that he's made a mistake. That's for the jury to decide. That's number one.
He acknowledged it in this case, and he's already acknowledged that he did it in the Stallings case.
Talking about the large quantity versus what?
Yeah, that's a big mistake.
He says it was a mistake in choosing the wrong word. That's not a scientific mistake. No, you haven't any evidence that Dr. Long in any way failed to conform to a standard of proper care, which I'm not allowing examination on anyway, and you haven't shown that any scientist of any regard in the field of toxicology has attacked him. Now, the fact that someone thought it might be interesting to make a heart-rending movie about how this woman was unjustifiably convicted of murder because the science which then existed didn't recognize some things is not an attack on his reputation. So no, the subject's closed, and I don't want to hear any more argument.
Judge.
No, I don't want to hear any more argument. You may make a one-sentence statement for the Court of Appeals.
I believe that the court has misinterpreted the reason for introducing the evidence because it is being offered to show the effect on reputation based on his mistake that caused a person to be convicted of a crime they did not commit, and it would be adverse to his reputation to again have made a mistake in a high-profile case involving an ethylene glycol case in which another person may be convicted of, wrongfully convicted of homicide.
I think this is recommendable. You got all that into one sentence.
It was a run-on sentence, though.
But I thought it was well done. But anyway, and the answer is no. And for a variety of reasons, beginning with the fact that you didn't even establish that he's committed a mistake. He made a mistake. No, I'm not going to argue about it. I've made my ruling. I think the record is full. I gave you a chance to state it, and we're done. And so you will not be permitted to ask him questions on the subject of bias. You may ask him about whether or not he was he had created an exhibit which didn't fairly represent what was depicted in the scientific experiment which was conducted. Is that the right word? Experiment, procedure, whatever it is.
Yes, sir.
All right, ready to go?
Yes.
Ask the jury to commit this.
And just so that I remember, it was Dr. Long was still being cross-examined when
You are correct.
last time.
You are correct. Did you? Yes. Exhibit D206 will be received for record purposes. Tammy.